Here are 7 common mistakes when thinking about driving offence loopholes. Number 1 is thinking that it is somehow against your human rights or breach of data protection to be required to identify the driver of a vehicle. Section 172 of the Road Traffic Act, or a 172 notice, requires the keeper of a vehicle to identify who was driving at a given time, and failure to do so will constitute an offence unless you can show that you've taken reasonable diligence to find out who it was and still cannot do so. But simply saying you can't remember is not going to cut it. Besides, the ECHR provides that the keeper of a vehicle is required by law and obligated to give information as to the identity of the person driving the vehicle at any given time. Number 2 is the belief that until you register a vehicle that you can drive it on your old insurance policy. But this is wrong as well, because as soon as you buy the car or you pay for it, you take possession of it or part exchange for it, you enter a legally binding contract and you are responsible for that vehicle. You don't necessarily have to be the registered keeper of the vehicle in order to be considered the owner, and thus in this situation you are not driving someone else's car, you are driving your car, whether you are the registered keeper or not. Thus you are required to have insurance. Number 3 is thinking that minor mistakes on a fixed penalty notice will make it invalid. Now this is wrong as well for many reasons. A fixed penalty is simply a summary of the offence and an offer to you to resolve the matter quickly without going to court. It is not a comprehensive breakdown of all of the evidence against you, which the police have for any given offence. There are very narrow circumstances where mistakes on the fixed penalty might render it invalid, but that's not normally the case and you cannot normally rely on that. More often than not, if you reject the fixed penalty notice, you'll end up in court, and it might well be far more serious than the fixed penalty would be in the first place. Number 4 is that you think it's only a very minor offence, such as speeding 33 in a 30, and that if you ignore it, the police will just let it go and they won't bother chasing you for it. But again, that's wrong, because regardless of the severity of the offence, if there is sufficient evidence against you, you may well find yourself in court, not just for the offence itself, but for your failure to respond to it at all. Number 5 is that if you name somebody who is a foreign national, then the police will just forget about it because of the difficulties associated with finding someone who lives abroad. This used to happen quite a lot, but the police are now very familiar with this, and the raw truth is the police are going to assume that you're trying to get out of it in an attempt to avoid the points for yourself. The upshot is, if you cannot provide proof of this, then you are going to be charged with allowing someone else to drive without insurance. Number 6 is taking some template letters that you find online and firing those at the police and assuming that they won't take any action because you've somehow challenged it. Again, this is wrong, and again, the police have seen this time and time again. They see these letters in bulk, and again they will just assume that you are trying to avoid liability. Worst case is that you might be challenged for trying to pervert the course of justice when in fact you were guilty of the offence, particularly if there is strong evidence of such and it's just clear that you're trying to avoid liability. If you have a genuine defence or it genuinely wasn't you, I would recommend that you try to put this across properly and truthfully rather than try to dodge, duck and dive the offence, because that might just make matters worse. 7th and finally, and probably the most severe of all, is that the belief that if you give the points to someone else, the police will be satisfied that someone is guilty of the offence and they won't follow it up anymore. I say this is probably the most severe because this does amount to perverting the course of justice if in fact you were guilty of the offence. And if the police can prove that it was you that was driving and not someone else, the most common scenarios of which is a man saying it was a woman or a woman saying it was a man driving, and it's quite clear that it was their spouse and they're trying to avoid 12 points on their licence to avoid a totting up ban, then both parties might end up in the Crown Court for perverting the course of justice, which is likely to be a far more serious offence than the original offence was in the first place. So please try to avoid all of these quick fix loopholes that you see on the internet. Speak to somebody about your particular situation where you may well have a defence, and if not, you just have to take the points and the fine, particularly if it comes about by way of a fixed penalty, because that is likely to be less than you'll get in court. So please give the video a like and subscribe because that really helps my channel. Hit the bell icon so you get notifications of new videos, and thank you for watching.